I need your input and your expertise to make this kind of decision. Thank you for your time. Thank you.
I'd like to give you a good example of how rulemaking can really affect the way things work. How many people in this room have been in a casino in Colorado? Okay. The constitutional amendment that allowed limited stakes gaming in Colorado said that no more than 50% of the floor can be used for limited stakes gaming purposes. If you look at a casino in Colorado, you tell me where that 50% is. What they did was through rulemaking, they decided that the gaming device's footprint was the limited stakes gaming area. So I would have looked a long time before I got to that solution to the problem. But when you look at the casino floor, what you're looking at is the number of machines divided by the square footage. It doesn't have anything to do with 50% of anything other than just the footprint of the device. So when they do rulemaking, and they're talking about the 70% rule, the 30% rule, that's when the industry really needs to step up and say, this is the way it works. Because you know as well as I do, if you're a grower, all of those little devils that you're growing are nothing but hope until they hit the drying iron.
I was curious as to whether or not you all made a decision about the licensing fees for optional grow and infused product manufacturers.
We're looking at, for optional premises and the grows, again, correct me if I'm wrong, somewhere between $1,000 and $1,500 in that area.
As far as the edibles manufacturing?
Exactly the same fee.
Okay, so if I had an edibles company, I would pay $1,500 for the edibles license and $1,500 for the optional grow. Okay.
This question is for Mr. Cook. Everybody in this room is trying to be as compliant as possible. Many of the edibles/infusion companies are fairly new. Currently, medical marijuana commissary kitchens do not exist. And the people who are trying to take their commissaries and make them MMJ compliant are working feverishly to build walls and put in doors and do things like that. The deadlines that we have right now are pretty strict. Is there anything that you might be able to do to help with those deadlines so that our edible manufacturers are not shut down totally?
In terms of the July 1 deadline, that's a statutory thing. I really have no flexibility with that. But I will tell you that I believe it's Monday, and I'm meeting with a group of folks that are in that business, that line of business, to learn more about their needs. And really, I thought you were, yeah. And so, I mean, that's the best I could do is to meet with you, try to understand your business and the needs of your business before we move forward at this point.
Okay, thank you, Mr. Cook.
You're welcome.
Through many discussions with multiple growers that I've dealt with, one of the big questions is that if I already have an established grow, I'm current with all the local licensing, and my business is going to partner with a center. Do all of my leases, my local licenses, and everything that I already have in place need to be redone, and the relationship with the center be set in stone by July 1st? Does all that have to be reapplied for and redone?
Anybody else like? Can't lie to yourself. No, it doesn't need to be done by July 1st. In fact, your certification isn't required until September 1st. The application comes out in August 1st, and I just threw a lot at you. If you're going to make an application, you're going to, quote-unquote, marry with another entity, do it by August 1st for my purposes. But to go back to what Charles pointed out earlier, until this bill goes into effect, you are still subject to the local kinds of things. And you really need to communicate with your local government to see what it is that they're wanting, because I can tell you what I need from the state's perspective, but I can't speak on behalf of local government.
So can it stay in my name? I mean, it's not me, but does the grower, can the grow facility stay in their name in order for them to apply for that optional grow license as a partner with the center? does have to be changed.
No, they can't. And again, the statute requires that only a person licensed with a center license or an infused products license can have a grow license. Person is defined in the statute as well.
Please correct me if I'm wrong, but in reading House Bill 1284, I thought I had read that in purchasing the 30%, that is taxed. Is that correct? And then it's taxed again at the point of sale? Or am I misreading that?
Now, I believe you're right that what was contemplated, this was pointed out to me by somebody else, but I believe what was contemplated on the front end is that everything was going to be a retail sale. Now, that poses some problems because wholesale transactions don't have a retail tax, and the Department of Revenue tax side of things is going to have to work through that. And for the record, have nothing to do with taxes. Okay? So,
But it does read as double taxation.
it does. I agree with you.
Okay, thank you.
Could you offer, this is for cultivation, could you offer a definition of the minimum requirement, the minimum acceptable delineation between if it's an OBC and mid grow or IBC grow or separate companies? For example, would a chain link fence that has a lockable door, would that be an acceptable minimum standard?
It could, absolutely.
Mr. Cook, I know that the residency requirements for dispensary owners are going to be 2 years. For employees of those dispensaries, I was wondering if you guys have any information for that.
Right now, the way that I've interpreted the bill is that an employee, because they are a licensee as well, they're also going to be subject to the same requirements. But candidly, I intend to ask my Attorney General for some guidance on that.
I just want to mention that we're only going to take questions for the people that are currently in line, so we can wrap up the session. Go ahead, ma'am.
My question is there are there any dates being talked about for the public input on the rulemaking processes?
The dates have not yet been set, nor have the participants in the work group. I'm still out trying to meet people and know who does what in the industry. I mean, you have really true key stakeholders and very good spokesmen. Rob tonight volunteered. I absolutely welcome his participation. But I need representation again. I need the patient side of things. I need patient advocates. I need doctors. I need small grows, large grows, small dispensaries, large dispensaries, metro dispensaries, dispensaries from rural areas. I mean, everybody sees things differently depending on who they are, but you all have a voice. And so I need to find out who can best represent each of those groups moving forward. That's what I've been working on for the past 7 months.
So this will be a working group first, and then there'll be the general public input, or the...
Yeah. The way that it works, and I want to be very clear about this, because there's no hidden agendas with this at all, and this is just the experience of doing this for many, many years. The statute only requires me to do a public hearing to promulgate a rule. I would be foolish to think about doing a public hearing without working with the stakeholders that the regs are going to affect. And I gave you that on the front end. My hope is that through these work groups, we will find consensus on many of the very tough decisions we need to make to move this industry forward. If we find consensus, we can turn a reporter on before a hearing officer and conduct a hearing and do this in very little time. But a hearing is absolutely a public forum, and anybody has the opportunity to testify at that hearing. Yeah, go ahead.
And I just add one thing to the hearing process, or the rulemaking process, just because you're going to be represented by folks that might represent your individual interests. Please try to seek them out in the early stages to give them your opinions, and so at the end of the day, you're not saying they didn't represent me or they didn't bring my ideas to the table. Try to look at or get on our website, find the drafts, get the things that we've got, and give them your opinions, because they're going to be your representation to us and to the process to educate us. And if you may have a point that you want to make that they wouldn't think of, that they need to bring to the table also. And it really does. They'll be your representative.